of the offending paragraphs were removed in part, but one of them was totally expunged from the witness statement. It is pertinent to state that one of the offending paragraphs related to the pedestrian allegation of Asiedun Ketia in his witness statement that the chairperson of the Electoral Commission has a familial relationship with Her Excellency the First Lady of the Republic, Mrs. Rebecca Akufo-Addo. We all witnessed the strenuous and tedious submissions by petitioners' lead counsel to answer to the objections which had been raised to portions of the witness statement. It was a repetition after repetition, which prompted lead counsel for second respondent, who could not bear it any longer, to remind the court of the petitions, of the repetitions. When Mr. Johnson Asiedun Ketia took to the witness box, he remained largely evasive. Every question that was posed, his immediate response is that I do not speak for the petitioner. This is someone who in paragraph 2 of his witness statement has stated clearly that he was in court to end or lend aid to the petition filed by petitioner. How can you come to court as a witness for a party, and when you are asked questions in court, your response is that I don't speak for the petitioner? Then why are you in that court? Why are you then in the court? He thinks he can be as elusive and invasive as he was in 2013. This time around, he will not be lucky. Now, it is very instructive to let all Ghanaians know that the one person who filed the petition, which is John Dramani Mahama, has refused, failed, or neglected to sign onto a witness statement. As we address you this afternoon, the petitioner himself has no witness statement before the court. This is a petitioner who seeks to have the elections annulled and is praying for a rerun. This same person is refusing to come and give evidence in court. The judgment is with the Ghanaian public, not mine. When Johnson Asiedun Ketia went all about town, he said one thing which is poignant. When he was posed a question by a lawyer for first respondent, his response was that we are in court to challenge the conduct and constitutional duty of first respondent. We are not in court to challenge the elections. I mean, that is Johnson Asiedun Ketia's own statement, not mine. We are in court to challenge the conduct and constitutional duty of first respondent, not the elections. So this is where we are. As I always do, I will allow you to ask questions, if any. First question.
At the latter part of proceedings, you made a request, wanted to confront the witness with a certain video. I mean, we're just wondering how exactly does that help your side of the story? Because the contention that they have put in their petition in terms of what they have filed is to make the case that...
Can you repeat your question again?
Yeah, I'm saying that at the latter part of proceedings, your side put in a request for a certain video to be allowed so that you confront the witness with it. I'm only asking you to explain to us how relevant it is to the case, in that the substantive matter that is before the court is the claim that no one had more than 50% of the votes cast, not the claim that no one won, like that someone won by more than 50%.
In court, the test for every witness in court is the witness's credibility. So you realize that when we went on and on and on, the final leg of the submission was that we want to attack the credibility of the witness. And it was at that point that the court was minded to grant the application for a play of that video. Now, the relevance, to you it might not be relevant, but the relevance is that these are persons who, after or during the course of the elections, had proclaimed to Ghanaians. In fact, the presidential candidate himself, John Dramani Mahama, the General Secretary, Johnson Sedun Ketia, the Deputy General Secretary, Otokuno, the Director of Elections, Evisafi Ankra, and their communication officer, SAMMY GYAMFI, had proclaimed to the whole of Ghana and the world that their presidential candidate had won the presidential elections, and they had secured, some were saying 140 seats in parliament, others were saying 141, others were mentioned that they were not even sure. And when they proclaimed that they had won the presidential elections, they gave you percentages. Don't pretend as if you didn't hear. They gave percentages. And some of them were calling the presidential candidate president-elect. I think I recall, SAMMY GYAMFI, a communication officer, referred to Mahama as the president-elect. Some of them even urged him to form a parallel government. Now when they are being invited to the police, there's another story. They advised him to run a parallel government because they had won the elections. Now these are the same self-people who now, when come to court, cannot even tell how many votes they garnered, and are asking for a rerun. Does that sit well with you? And you think it sits well with Ghanaians? No. But you see, I must point out also that the exhibit that Asiedun Ketia was confronted with was their own exhibit. The exhibit E. It was their own exhibit. In his testimony, they failed to sign on to regions where it was abundantly clear that the petitioner had won elections there. Their agents in the strong room decided to take a long jump when they realized that the results proved unfavorable in their cause. That is my answer.
All right. My question is in reference to the claim, the remark that you said Mr. Johnson Asiedun Ketia made in court. Indeed, what we heard him say was that he is not the petitioner and not that he does not speak for the petitioner. You are lawyers. When somebody says, I am not this person, it's different from saying, I do not speak for that person.
Have you read paragraph 2 of his witness statement? Maybe if you read paragraph 2 closely, on Monday when I come, we can have that engagement. But when somebody says that the petitioner stood on the ticket of the National Democratic Congress to contest the elections, and I, the General Secretary, the Chief Executive Officer of the party, I am swearing to a witness statement to give evidence in support of the petition filed by the petitioner. Would you still want to maintain your question?
Well, I just want a difference, to know the difference between when someone says, I am not the petitioner and I do not speak for the petitioner.
A witness only corroborates the case of the party. You don't become a witness in court because you have sprung up from somewhere, maybe from Mountain Kilimanjaro. You become a witness because there is a necessary party in the case. John Dramani Mahama has not donated a power of attorney to anyone to speak on his behalf. It is Johnson Asedun Ketia and Dr. Kwesa White who are coming to speak as witnesses. And they all state that they are speaking in support of the petition. So you cannot come to court and lend aid to a petition, and when you are asked questions in court, you say, I am not a petitioner. So what are you? Are they aware of SAMMY? Yeah.
Okay, that's it. Thank you very much. Thank you. Thank you.
I would end, as I always do, if you have nothing to say about another person, whether that thing is useful or beneficial, then please do not say anything at all. Because if you invariably say what you want to say, you will prompt the other person to also say something or respond in a way or manner that may or may not just otherwise be pleasant to you. Let's all be guided by fidelity to the truth and don't bear false testimony. Thank you.
Major Chief for lawyer upon now on Cassette here. Lawyer.
Okay. You remember the tougher. Near Ohoni say, Emre Musa, the Assemuba Kota. Ese and some no nina pese court no. Ejitmuno. Udini nina betu continent. Maybe Sadia Chini say, Ode assemble by nature no. Obesi Sawano. Ubronisa obe surprise other party no. Inti empenisa. And it ube here Ura Mahama de assembly bar court no. And sembi oha okaye. Nenso ora say dunketia de witness statement ne bae no. Nsem bi wo na Mr. Mahama na nkasa ya ni case no. Wan fanshim ne kobasa na enye so wa surprise ye won chen no nko na mom ukura mpo ye ma se ya me ye twam sisi efi se ade emrachi eni so obi di na asema ba na ni witness eni na ji ho achinyi efi se ni witness ne ka no soronko efinia nipa na so de asem no bae no e kan ti twakura atwam sisi na ye efi se enkewie case ni tra addresses a enkebi ensem e be ka wo mrakwan so no e ma asem no kure betwam ntem enti bi say say omoda yase ya bo a omsabre na ne ho biem ni say senia ensem ne course ne no ubehu say ensem busa no e ba no de se bi munyina mo wo court ho muhu senia no ye ne ko ye wie enti mi nkan kosi ase bebre nanso ba bia ye du ni say ensem busa ne ba ye say eyembra ye to aba ni wie ye no penimfo bi e wo NDC mu ena Mr. Mahama nkasa former president omo kan se abane de Ura Mahama ena ewini
one touch
mi kuma me chia ne sisi asami GYAMFI nso kan bi se president elect na akono ye nanso na nipa bebre ehwe ni mu senka Ura Mahama de case ba Supreme Court no obeka se yentwa abatuo num Ura Kufuadu enwini ne momo Ura no Mahama no na wini na nka yenka se Supreme Court enkansi so senior 2013 na Kufuadu de ba court no so ekoye nwanwa se omo ba court no Ura Mahama se wanwini ne momo Ura Kufuadu nso anwini enti no eba ne saade a yenkoto aba ne mo mienu nya na gum ne akuadon kom nyina yenfo mu nsinchen enti eho ne egina sese enti o de tru nsem a sebi ono ani na pamfo ekan ya ema supporters bebrani giye eni be bi anka esese otimi kansi so sampa mi wini ene bi a ya wia me no antimi ameka se mpo ya wia no na wanso antimi ameka se me na mi wini ye ne ya bu me bukata no eno ne ma krofo bebre adwemu ye o na kakra nti ebi adwada ye bo video no ana tape na munyam be hwe bi atie bi na se bi munyam ye badwema na motimi di mani ni maso nyina abu ba bi ejina no tie dam ase.
Good afternoon, ladies and gentlemen of the press. I want to start by letting you know that today was very eventful. And I'm sure when you watch the proceedings, you came up with the impression that the John Mahama team brought a solid case to the Supreme Court. In fact, when we filed the petition, it was being bandied about all over the place that our petition was empty, that it had not disclosed a reasonable course of action. Well, today was your answer. I am sure you saw vividly the evidence that was being led by the General Secretary. We have not yet concluded the hearing, and so I will not comment on the merits of what he said. But I'm sure you are all witnesses and you know that this is not an empty case. Now, let me correct one misrepresentation, very deliberate and gross misrepresentation that lawyer Frank Davis, my very good friend, has made this afternoon. He sought to give the impression that we came to court because we wanted a relief to the effect that His Excellency John Dramani Mahama be declared the winner of the election. I am sure, as ladies and gentlemen of the press, you have read our petition. Nowhere have we sought that relief from the court. What we have sought from the court is very simple and may be summarized in two. First, we want the unconstitutional conduct of Jean Mensah to be held to account. Secondly, we want the court to declare that none of the candidates met the threshold requirements of Article 63, Clause 3 of the Constitution. That is the crux of our case. And that is the case that we have sought to make in court today with the witness statement of the General Secretary of our party. Now, it is far from being the case that John Dramani Mahama himself must testify in this matter. He has filed a petition. He is entitled as of right under the law to call witnesses in aid of his case, and that is what he has done. In 2013, His Excellency Nana Addo Dankwa Akufo-Addo never testified. Ladies and gentlemen of the press, if you have evidence that His Excellency Nana Addo Dankwa Akufo-Addo testified, please bring it to us. He did not testify. He called witnesses to testify on his behalf. So is it the case that when it comes to His Excellency John Dramani Mahama, the law must change and compel him to testify? I am surprised that a senior lawyer of Frank Davis' stature is confusing petitioner with witnesses that the petitioner calls. Also, it played out in court today that if we had done proper case management, as we were pushing, we would not be where we were this afternoon. You remember we complained bitterly that case management, as stated in CR 99, was supposed to last 5 days. The court compressed it to 2 days. And in fact told us that we had spent the first day of those 5 days making the case for the interrogatories. Now, it played out in court today. The importance of case management. When they sought to tender the pen drive that contained the so-called videos in which principal officers of the NDC and our presidential candidate made certain statements, you saw what happened.
the court was not prepared to play that video because it had not anticipated that it will be needed, and there was no equipment in court for that purpose. As practitioners, we know that at case management, that issue would have come up, and the court would have been prepared that on day one of the trial, a video will be played showing evidence of statements that our principal officers made. Ladies and gentlemen, it is very important for us as a party to underscore the fact that we are not in this case because we want to joke with the Ghanaian people. At the end of the day, the issues of accountability, the issues of the mathematics of Article 63(3), and you very well, you saw it in court. When calculators were flying around, were we the ones who brought the calculators to court? Were we the ones who brought the calculators to court? But we warned you that this case, a big plank of the case concerns the mathematics of Article 63(4), whether or not Nana Addo Dankwa Akufo-Addo, as a presidential candidate, crossed the constitutional threshold of more than 50% of the vote. Our case is that he did not. And we will prove that in court. Just watch out in the next few days. Any questions?
Any impact on the case as you have put together?
No, we don't think it has any impact on the case we have put together. We are allowed to bring those matters back, when cross-examining their witnesses. So we don't think that it in any way, destroys our case or minimizes the probative value of whatever evidence we are bringing. But note that they raise the objections based upon the so-called scandalous nature of some of the averments or some of the statements in the witness statement. All right? Now, we had alleged that she acted in a biased manner, in an arbitrary manner, in a capricious manner, that was motivated by personal dislike for His Excellency John Dramani Mahama, or if you put it in the converse, her likeness for Nana Addo Dankwa Akufo-Addo, her preference for Nana Akufo-Addo. And that is how come that in our witness statement, we sought to make it abundantly clear that she had a familial connection to the Akufo-Addo family, that she's a relative of Her Excellency Rebecca Akufo-Addo. Now, if that is not material, what is? If you are a family, a relative of the First Lady, are you telling us that you don't want her to continue to be First Lady? So we said that she did it, with a predetermined agenda designed to continue, to let her sister or cousin continue to be the First Lady by announcing that Nana Addo Dankwa Akufo-Addo was the president.
So you have made it clear to us that the petitioner himself will not be in the box and that he has assigned witnesses to make his case for him. However, in court, at least more than 5 occasions, the petitioner's witness declared that he was not the petitioner and therefore did not answer certain questions that were thrown at him.
Well, that's an excellent question. It means that you were watching the proceedings. Let me make it clear that in those instances where the witness said that he was not a petitioner, they wanted the witness to give evidence with respect to the state of mind of the petitioner. Okay? Anything attributable to knowledge that is within the personal, knowledge of the petitioner. How do you expect a witness to be able to testify to those matters? And that is how come that he legitimately declined to do so. It is not because he is distancing himself from the petitioner. In fact, he is not here under compulsion. He voluntarily agreed as our general secretary to testify because he is the chief administrator of the party. He coordinated with the help of the chairman and the other principal officer. He coordinated the election. So who better to, testify on our behalf than our General Secretary? And that is precisely what he was doing. But if you insisted that he should speak the mind of the petitioner, he should testify to matters within the knowledge of the petitioner, he would decline. And that was just as it should be. And in law, the General Secretary was right in declining those questions. Any other question? All right. Thank you very much, ladies and gentlemen of the press.
Okay. Let me just do the doc. Let me do the Abusian for your best friend. Yatre and then the course so the Supreme Court of Ghana mu ewutwi kasem. Na ansakra na metre de Dr. Ayine aka no poto kasem wutwi kasem mu no. Frank Davis oye kasamafo Emma the second respondent eye Nanado Danko Akufuado aka nsem bia ewo se yeyi ano na ma Ghana for anye sebio sa inkuntumpu sem no antum yedi kan samutie ni a oyusu word bi say about 10 passages na ewo General Mosquito witness statement mu no omo ka say court no mungu na court no bo munsungu ye because sansem no a pedestrian chese sebio a yakushisem obusanfo mu nyina mo hwe de course wo court ni bi wo TV so court no bo sa nsemfu anso na gu no court na nka ba bia se a pedestrian court na nka se yakushisem omo person ka court no be bo sansem na gu because a yakushisem a scandalous be court na ntie the court no kan ya ne say wabo sansem so no agu because say any your petition the dear friend of pleadings it has no foundation in the pleadings. That is different from say obeka say and someone a General Mosquito adanse crater mu no a pedestrian na ye pay attention and ye raise this issue because of bibi ekwa yenuano wa omokasama second respondent suban say maybe a be free court aba ha bia no omo be yusu kasetwie ene sebin semu a eni say free a lawyer for ano e de akasa fa de course wo court. The last time it was intransigent and right it was somebody who had a jaundiced mind and there will be a ne passages here pedestrian ye be sere ni diem say a lawyer for we are this year money atete ye wokwan ya wase ye fa so kasa enu nti se wo free court na waba be kan nsem a akoso wo court wa the court nkan ye no enkan hye court na no if the court in dismissing or upholding those 7 objections no did not say a pedestrian imagine bedwem meka that conduct no is unbecoming of a lawyer of the standing of Frank Davis. Ye be stress ye nyina ye be condemn se na be ya enkoso because ebetimi aha asemu a court no edi de atoso biem oka se omampanyi John Dramani Mahama ode na asema ba court o ye petitioner no onfa dance krata bia maaye enu nti no no kire se oni asem bia te se de Dr. Ayine chechire mu opoto kasam no sa asem no so eye mfuturu a ye nuanom etugu Ghana fo ani because wo mramu no so what the was send to court and him say court on kawasema as petitioner bibia ni we hye say e wo say wa obedi adanse ma ho emrane ma ho kwan say utimi fra dansefo ma adansefo e bedi adanse ma eno nti na in 2013 election petition no o mampenya Kufuado de na assemble as the petitioner no ono wa medi adanse ni bi wa ma obi aso mra krata the friend of power of attorney say o megina nenamu eya dansefo Dr. Bawomiamo eno from mo hu bedi adanse ma no enti de yewura John Mahama aye no edimu ewo mramu a bibibo ni bi anim ti nsem a ye nuanom kan ne no so no eni nyina so bia wo mram ti e be stress eno so ye de beto nchen ebiem oka se NDC for emra ye to aba ni wie on 7 December ye ka kira wiase nyina se ye coalition ye nkonta ye bu kire se ya win election no but ye ba court no ye ka asem foforo se court no order for runoff na no kire se ye witness asiedu nketia na NDC for ye nya no kwafo obobo ye nyina ye di ne de keka ho abusianfo sa semi a ye nuanom MPP fo aka ne he ya o maka ne babi bebre no the trend part say, yes, somewhere at the Abba court no or Montiasia. Intia Yakasa and say, yes, somewhere at the Abba court no has got nothing to do with your coalition. Any figures are your one remuno. So bit ya will now soon prim. Now the lawyer for 2 courses of action against the person. One I will be choose the whatever court can. Inti ampa yeah press conference based on pink sheets ne results are your coalition yaka say John Dramani Muhammad Nkunim. But assembly ya the court, and that is not the nature of it. Assembly ya the court has to do with the constitutionality of the declaration ya GYAMFI. Yes, the constitution they say who declare will be say wa when your mampeni abatwa. I was a sign nipa krono when ya emapanumu or hamu chichemu adunum ni achire. Per ensam figures wa declaration no mampeni kufuadu enya. Until we declaration ni tiaga na mra kunyini 1992 constitution. Not just a mremuno declaration doesn't even exist. So if the declaration doesn't even exist there, then issues about the coalition, in the view of our lawyers, so we have elected to challenge the constitutionality of the declaration of GYAMFI. That is what is in court. At the appropriate time, say was said, yakasa about the coalition, dance ya chesa ya arena, ya become one. But let in some way can about the course of court, Yaman fa in some way that court name, which is about GYAMFI Juma Waye, about Wabobo, and whether or not to say a dimu results are declared a dimu ewo emrem. Abusian for a BM Omaka say, oh, Yura Johnson, I said, no, Ketia Dansimuno. Oka say he is not John Muhammad the petitioner. Intiano Chres say. Yura said, don't get nim the Oka na petition and in Nimasem. Oh, the Ayane say, a lawyer for a woman day. Pa, or Motes ansem we aseno. It may be a free quarter, baby, no banomutum for Ghana for any. What's here, dear Frank Davis and Kazakaya? Or say paragraph 2 of Yura, I said, don't get dance crata. And they will say, he is giving evidence in support of the petitioner. In support of the petitioner doesn't mean say, I am giving evidence as the petitioner. What that means, they say, as a witness, evidence or they support to petition any case, what the lawyers will say matters within his personal knowledge. And this will be a question, say, now central phone share movie as a John Mama will be a wajia to a one case on your petitioner because I know the name. Now, baby, and question, say, petitioner, no, the money can't be. And I didn't want Timothy or ye bibia. And someone who pass a cano. They are not within his personal knowledge. And ni on one casa nindium to a man what dance your crowd tomra. That should show you, say. And now you penny mupa or dear danciano, or you're no call for. He is credible. Say, and somewhere here within the personal knowledge in Guano Beckham was them. Now, we shall for Yeba, the course or court to Nimuno. A course or court. I'm more share. Some bisabe break also say agents assign way which new agents or munye which new they said the general secretary can ye but the same way the Aba court has got nothing to do with that. Obe bobo aba on 9th December e ka kire Ghana for so mampenye Kufuado arene we see total valid votes a wugina so ka say warene no e 13,434,574. Yekoye nkonta wankasa wayan wo declaration ni mu a o mampenya Kufuado anwene per wankasa wo figures percentage awodi ama no enye correct assumption waye say ye detachment south nyina ka ne ho a still candidate mama nsan ne ho enye correct kwansima de achen ya na wasan so at the press release anokra de obi ansan sha ase aba eno so total valid votes a wo de bu nkunta ka so mampenya Kufuado anwene ye sen a they say the 13,434,574 bim. Almost say 13,119,460. The figure necessary. And no ma catch Ghana for nyina GD so my many young fonso wa correct in fonso. Afeye Rajon Mahama at the same way back court. Yes, my miji mensa. Betchre and Madodo Ujina so declare John Mahama Renia. Correction Nanado Arenia. correction our no 10th December and no Ghana for Munina Majedi. Say no na real results. No what paragraph 12 and paragraph 24 of her answer to the petition. Or they say the figure no. And yet 13,119,460 now can the 10th no. Now 13,121,111. There's the figures now yamiensa. After your call website, also with the 275 constituency summary sheets ago. Obia betimi akwa fa na wakan ne wahu abato no sunsanso. Ne ye kwake sienia total valid votes ne yesen a eno so 12,218,633. That is about to ba kwa yato. O results nko abro nan ne akire. Debia esesa. Na eno nana Yewura Johnson Asiedu Nketia eka ho asem say that is the issue before the court, and we are saying say Sawutie ma me nankasa nu mu asem ni figures or the two dwa no na no ne yesi ye de be ye adwuma de a ene no mampanya Kufuado enya more than 50% of the total valid votes eno nti wani inkunim nti abusuafo de ne course so court in the court to ahye se ejoda ye beba na Yewura Johnson Asiedu Nketia waba ababetoa na dance so na yeba eno so de besi bia no ye ne mo ebedi hu komiti adam wase.
Thank you.
You are going to.
All right. Thank you very much. And that was the two press conferences held by the petitioners' side and that of the second